Okay, good afternoon, everybody. My name is Allison LaFrelita. I'm the Executive Director of the Nonprofit Resource Hub. I would like to welcome all of you here to today's webinar, Navigating Conflict of Interest Transactions. This webinar is presented to you today by Judy Siegel, Senior Staff Attorney at Pro Bono Partnership, and David Goldstein, Partner and Head of the Nonprofit Practice at Certilman, Balin. Today's webinar is presented to you on behalf of the Nonprofit Resource Hub. If you're not familiar with what we do, we're a community of professionals providing goods and services to the nonprofit sector and nonprofit organizations in order to provide them with support, education, and services, as well as Nonprofit Westchester, an umbrella organization representing nonprofits and the communities they serve. If you're not yet involved with either organization, I encourage you to please go to our website, check out what we're doing, and reach out. I would like to thank Judy, David, and the associate membership of the Nonprofit Resource Hub, as well as Nonprofit Westchester, for your participation in today's webinar. And without further ado, I present to you Judy Siegel.
Thanks, Allison. All right, so first of all, hello, everybody. Thank you so much for joining David and me. And we want to say thank you to all of you for all you do for your nonprofits and for the communities in which you're based. We both appreciate that this topic, while critical, may not be the most riveting discussion you're ever going to have contemplated. So over the next hour, we're going to try to be as non-legal as possible and leave you with the knowledge of how to consider, analyze, and document related party transactions and conflicts of interest. To that end, we hope that you ask us questions by putting them in the Q&A feature. And if we don't get to them, you can always reach out to us afterwards. You do have our contact information. At our core, David and I are lawyers, so we have to give you the disclaimer that anything we say today is purely educational in nature and should not be construed as legal advice. And to that end, please remember, if you ask us questions, which we hope that you will, please do not put confidential or proprietary information out there for everybody to see. Protect your intellectual property and your knowledge, people. All right, here's the other part of our disclaimer, because we are lawyers, and let's get down to it. So for those of you who don't know Pro Bono Partnership, in a nutshell, we provide free legal services to nonprofits. So more specifically, partnering with volunteer lawyers from in-house legal departments and law firms like David's Certilman Balin. Last year, we supported about 1,000 nonprofits in New York, New Jersey, and Connecticut, provided more than 38,000 hours of free legal services valued at over $11 million. So that's $11 million that went back into the community. And we also answered more than 1,400 resource calls to our general hotline, allowed and provided a mechanism for lawyers to volunteer in their areas of expertise. And we provided approximately 50 webinars and workshops like this on topics of interest and concern to nonprofits. When I say we provide free legal services, I mean we do everything except litigation. So corporate governance and structure, bylaws, contracts, employment law, environmental law, real estate, lending and finance, tax law, you name it, we do it, and we will do it for you for free. So if an issue comes up, let mine be the voice you hear in your ear when you think, do we need legal counsel? And where are we going to get that? You should come to Pro Bono Partnership. So as I said, this is our mission and who we serve. And this is Certilman Balin. So as Allison said, David is the head of the nonprofit tax exempt group at Certilman Balin. He actually started it. He's also on the executive committee of the New York State Bar Association's business law section. He chairs the not-for-profit law section of that. And honestly, he is a lawyer's lawyer. He is who I go to. He is wise, he is smart, he is kind and good-natured. He is truly a counselor, as we use that term when we talk about lawyers being counselors. He's the best. So let's get down to today's agenda, because it is chock-a-block full, people. So, as you can see, we've got a lot to get through. We're going to talk about and start with the most basic question: what is a related party transaction? David and I are going to walk you through the relevant definitions as found in the not-for-profit corporation law, which we will also refer to as the NPCL. We're going to talk you and walk you through the mandatory conflict of interest policy requirements. And I do say mandatory because New York State requires that every single nonprofit in New York State, no matter how big or how small, have a conflict of interest policy. And what has to be in that policy is very, very detailed and mandated by New York State. So we're going to talk about that. And then we're going to talk about the process. As I said, there are detailed requirements. And to be clear, you're going to find those details in your conflict of interest policy. I will also note for you, the requirements in New York State are much more stringent than what the IRS requires or uses as an example in its conflict of interest policy. The IRS doesn't actually require it, but they think it's a good idea. And we're going to give you the tools, literally 3 cheat sheets to help you ensure that you're analyzing and documenting your related party transactions, your RPTs, properly. And finally, since David and I get questions all the time, and I mean all the time, about related party transactions and conflicts of interest, we're going to walk you through some common, practical, pragmatic considerations. So like I said, we got a lot to do. So can we enter into a related party transaction? Because I often get the question, hey, Judy, we want to know, can we do this? And the answer, unfortunately, is maybe. And I know people consider lawyers annoying, and my husband thinks we're the black hole of fun, but we're going to try to get you to understand how you can go from, hey, Judy and David, can we do this, to, hey, let's figure out how we're going to do it and think about this positively. So what's the first place to start? What do we have to consider? Well, first and foremost, you need to know what kind of transaction you're actually talking about. And interestingly, and I say interestingly because lawyers can be nerds, but interestingly, the law only contemplates financial transactions as a conflict of interest. So it doesn't contemplate what we would call a so-called soft conflict of interest, something like where a board member sits on the board of your nonprofit and then sits on the nonprofit of a similarly missioned organization that is fighting for example, the same grant money. So you can see how that could be a conflict of interest, but the law only talks about financial transactions. So that's the first thing to remember. Next, who is a party to this transaction? Well, the law is going to help you define that as well. And we're not only going to talk about who is a party to that transaction, but relatives that may also be a party to the transaction. The law is pretty clear about who it is and what it is, and we're going to dig deep into what the not-for-profit corporation law requires. So remember, only financial unless you choose to expand that in your conflict of interest policy, and the law is going to help guide you in figuring out what party or entity would trigger a related party transaction. All right, so the legal definition of a related party transaction, sort of stated broadly, is any transaction, agreement, or any other arrangement in which a related party has a financial interest and which the corporation or an affiliate of the corporation is a participant. That is your broadest strokes of what would be a related party transaction. But as we know, there are some exceptions, and David's going to talk about them a little later on, but we're going to start with the big overall picture first. And yes, your mind may be blown by, can we do this or can we not do it? But the answer is, we're going to figure out for you how you're going to do that analysis and process. So let's see if we can make it a little bit clearer for you. First, we're going to start by breaking down the legal description. So financial interest. Interestingly, but actually reasonably, the size of the transaction is not a trigger to an analysis for a related party transaction. It doesn't matter what size the financial transaction we're talking about is. And as we're going to discuss in a few minutes, substantial financial transactions, although not defined either, require some additional scrutiny and documentation. But again, the takeaway here, there is no magic dollar amount. And that actually makes sense because no two nonprofits are actually alike. What might be substantial, or even something that would make the board of a small community-based nonprofit that has, let's say, an operating budget of $5,000 or $10,000, sit up and take notice, would not begin to register for a nonprofit like the SUNY system or Northwell Health, both of which you should know, like actually all nonprofits are overseen. It's the same set of laws that apply to your SUNYs and your Northwell Health and your small community-based organizations. So again, it makes sense that there is not a single definition of what dollar amount triggers something. But we know it's a financial interest and there has to be a related party. So who is a related party? It's a director, an officer, or a key person. And there's some others. Relatives, for example, human relatives, is going to be a person that would trigger a related party transaction. And we're going to circle back and talk about key person and a relative, so don't worry. Also, entities in which other people own a 35% or more ownership or beneficial interest, or some kinds of partnerships and professional corporations. So let's drill down a little bit more about what the NPCL says about all this. So who is a relative? So we know it's a spouse or domestic partner. Oh, and this is coming straight from the not-for-profit corporation law. This is a defined term in the law. So if you're really curious, it's section 102A. But it's a spouse or domestic partner, their ancestors, not defined, brothers and sisters, whether whole or half-blood, children, whether natural or adopted, grandchildren and great-grandchildren, and the spouse or domestic partner of a person's brothers, sisters, children, grandchildren, or great-grandchildren. What's interesting to me here is who's not included in this list. So you're not seeing in-laws, you're not seeing aunts, you're not seeing uncles, nieces, and nephews. I'm just going to point that out for you. Whether or not that was a mistake and should have been added in, I don't know. Oh, wait, my boss is now walking in for some reason, I don't know. So we're going to take a brief pause. Oh, he doesn't have the link. He's just going to sit in and listen. So everyone, this is my boss, Mo, who just walked in. Stick your head in. He's my program director. But anyhow, so this is who is a relative, and equally important, who is not considered a relative for a related party transaction analysis.
So before we leave relative, one thing I want to chime in there on the side of the equation of how far-reaching the definition is. It includes all the way up to great-grandchildren, and in fact, domestic partners of great-grandchildren would be included in the definition of relative. So think about that for a minute. If you're responsible for making disclosure of transactions that the domestic partner of your great-grandchild might have with the organization or with an affiliate of the organization, that's a pretty broad net and pretty impractical to boot. So that definition and some of the other definitions are incredibly important in the analysis and in trying to manage the compliance requirements that all nonprofits have.
Your board is going to push back when you tell them this, and the answer is just going to be, this is what the lawyer said, and this is what the law requires. We can't get you out of this, try as we might. So now we're going to.
Yeah, sorry. And on that note, the part of the reason that the lawyers are telling you this is, number one, it's the law, so we have to comply with it. But number two, these rules and statutes and definitions and failure to follow them are featured very prominently in many Attorney General, New York Attorney General, Charities Bureau, enforcement actions, and also in lots of private litigations and in internal disputes in nonprofits. They really are a very fertile target for allegations of breach of fiduciary duty. And maybe that's something we'll talk about in a little bit more depth later. But that's another reason to pay very careful attention to this. Very often parties that have an axe to grind with a nonprofit or with a board will pay attention to these definitions. And so very good to take these claims off the table before they even happen.
Right, and not only will they be paying attention to these definitions, like I said, we've provided, or Kelly has provided through the hub, the cheat sheets. What we would encourage you to do is use those, because they're gonna make sure you're consistent in your analysis. And that is going to be very helpful should anyone ever ring your doorbell with a lawsuit or an enforcement action. The fact that you can go back and show we had these, we analyzed it, we are consistent across the board is also very helpful. And it's just a nice tool. Like, you can just hand them out and know you're on the right path. But let's talk about who is a key person, because that's the one that tends to trip people up. First thing to know, the phrase key person is a defined term in the NPCL, but it's not a lockdown kind of definition. So in fact, we're first going to talk about what a key person does not or doesn't have to be. So a key person doesn't have to be an officer or director, and it doesn't have to be an employee of the nonprofit. And this is going to become important as we discuss this, because I want you to keep in mind that people who are not employees, officers, or directors often have influence over the nonprofit. And that's really where we're going with this conversation. So let's dig a little deeper into who is key person. Looking at the second bullet point first, under section 102A25 of the Not-for-Profit Corporation Law, a key person is someone who manages the corporation or a segment of the corporation that represents a substantial portion of the activities, assets, income, or expenses of the nonprofit. So just step back and think about, who does this bring to mind? So if we think about Northwell Health again, and I am not picking on them, they're just so easy to use as an example here. So think about Northwell Health. So maybe the president of one of the hospitals is a key person. The deans of the med school could be key people, right? They have substantial influence over a portion of the activities of Northwell. It could be the head of government affairs, maybe the head of clinical excellence, chief operating officer, head of capital projects. So you see where I'm going with this. People who are in charge of big portions of the operation of the nonprofit. So that's one way you could become a key person. Next, if you look at section 102 of the Not-for-Profit Corporation Law, it also says that someone who alone or with others controls or determines a substantial portion of the corporation's capital expenditures or operating budget. So this one is pretty self-explanatory. But again, I do want to point out that substantial portion of capital expenditures is not defined, and that could in fact change from year to year. What is your capital expenditure? Nor is operating budget, which could also change from year to year. So that's why I said the definition of who is a key person is certainly not locked down or set or static. So now we're going to get to the most interesting one. And that is a person who has responsibilities or exercises power or influence over the corporation as a whole, similar to the responsibilities, powers, or influence of directors or officers. And the first thing I want to say is that, yes, if you're thinking, I wonder if that's a founder of my organization, because that person certainly likes to influence what goes on. The answer is, yeah, very often founders fit into this definition of key person. Next, I want you to consider the concept of time, which I touched upon a moment ago and which we're going to continue to explore. Because the definition of who is a key person may change from year to year, or even in a segment like quarter to quarter. And the relevant amount donated may change from time to time, because how much is an amount that's relevant or relative today as a large significant portion may not be down the road. So as I said, the definition of who is a key person is really, really nuanced, and there is no single plimsoll line here for this analysis, which is
Judy,
why.
Sorry, before we leave this slide, I'm sorry, didn't mean to interrupt. Finish your thought, and then I'll make one observation before we leave this slide.
Sure. So I was just going to say, let's consider a nonprofit that receives a $250,000 donation, and we're going to play around with whether or not that donor would become a key person. So if you wanted to chime in, by all means, do that before we explore.
Sure. Why don't you finish that thought, and then I'll make a, yeah. Go ahead.
Okay, so let's think of a $250,000, right? Any one of us sitting here would say that is a lot of money. But if we use Northwell as an example, because it has annual revenues of about $13.5 billion a year, and it has donations of more than $126 million a year, a $250,000 donation by someone may not actually catapult that person into the key person definition. So that's one way to look at it. But now consider that same donor and that same $250,000 donation, but assume it's going to a nonprofit with annual revenues about, $1.5 million. So now our analysis begins to look really different. So does the percentage that total revenue represent cause the person to be a key person? Again, the answer is maybe yes, maybe no, because there are other things you're going to want to think about. It depends on whether or not the nonprofit regularly gets that single large donation from that one person. Are they counting on that money? Does that money really play a significant role in what it does and how it makes decisions? Okay, so then maybe that person is a key person. But what if it's a one-time bequest that someone left in a will? Well, that same $250,000 and that donor may no longer be a key person. So again, that's going to go into your analysis. You're going to be thinking influence. And what if, like I said, what if you have this expectation? Does that expectation of the donation create influence? Maybe yes, maybe no. Not for me to say, but most certainly for you as a board to consider. It may also depend on the use of the money. So let's say the $250,000 is for general operations. And I know every ED and development officer out there just got a big smile on his or her face because we all love general operation donations. Thumbs up on that. But maybe it's not. Maybe you get this donation and it's to build a new gym. Now that's going to require a little more thought possibly. So you could say, okay, I'm getting $250,000, but it can only be used to build a gym. Well, maybe that's starting to talk about programmatic decisions. And that is the kind of influence that a board of directors would usually think about, right? Because that's really their job, big picture thinking. But maybe your board already decided to build a gym and the money's just coming in. So again, is that person a key person or not? We could look at many other factors around that donation to the gym. Does the donor get to pick the architect? Does it get to have a say in how the gym is built, how it's going to be used? Again, so many questions, but I'll get back to my point, really very nuanced. And also the timing on that. Are you getting the money in one lump sum? Are you getting it over a couple of years? All these are the kinds of questions we want you as board members to be thinking about. And if necessary, and if you're either David's client or a pro bono partnership client, pick up the phone and call us because we will walk through these issues with you happily. David, did you want to chime in?
Yeah, thank you. Thanks, Judy. And I'm glad you went into that detail. That was really helpful because this is a really critical definition. And one of the things that I think that this prong of the definition, responsibilities or power or influence, as if you were an officer or director, I think one of the things that this opens up for us is a window into some of what animates some of the provisions in the statute that deal with conflicts and related party transactions. And in fact, a lot of the statute is designed to address scandals that have come up over the years, and things actually that you may have heard about in the newspaper, or sort of common fact patterns where nonprofits are subject to abuse by insiders. So this prong, responsibilities of power or influence, similar to what an officer director might have. There was a Bronx state senator who wound up serving jail time for creating and abusing a series of nonprofits. And in fact, this gentleman had no formal role with any of the nonprofits, yet he controlled them. And so, here we kind of see this prong and that addresses that kind of a fact pattern. And similarly, as we go through the rest of today's presentation, if you haven't figured it out already, disclosure is critically important. You might say that the statutory scheme is almost fanatic about disclosure. And part of that emanates from the Adelphi University case in the late 1990s, where there were rampant related party transactions. There was no statutory definition of such a thing at that point. But pretty much everybody sitting around the table in the boardroom had business relationships of some sort with the university, but nobody else knew it. And so disclosure is something that the statute is fanatic about. And I find, and my clients tell me, that it helps them to understand how to deal with all these rules when they have a sense of where the drafters were coming from. So
right.
That's, yeah. Mm-hmm.
And I do also want to say, though, before we totally scare everyone out there listening to us, related party transactions and conflicts of interest are not necessarily bad. In fact, David and I would tell you they benefit nonprofits a lot of the time. So please remember that entering into them is not forbidden. You just have to do the work to make sure that they're in the best interest of the nonprofit. And we're going to talk about how your conflict of interest policy is going to help you figure that out. And also, please remember that David and I can draft you the most user-friendly, compliant version of a conflict of interest policy, or a related party transaction policy, or entering into a contract and a vendor agreement policy. But having the policy and then choosing not to pay attention to it or disregarding it is hugely problematic. So if you think back to that old Seinfeld episode where Jerry makes a car reservation and then he gets to the auto place and they have taken the reservation, but they won't honor the reservation. Same thing with having these policies. Just having them, but not making sure you're complying with them is hugely problematic. Not enough just to have one, people. You gotta follow it. But let's get back to friendlier ground. And David and I are going to talk more about this further on in the presentation. But in addition to key people, we also said we were going to touch on a couple other things like who is an affiliate. So what is an affiliate of the corporation? It's any entity, and this definition is from the not-for-profit corporation law. It's any entity controlled by or in control of the corporation. But because this conversation is governed by the not-for-profit corporation law and tax law in general, you should know that the word control is not in fact defined under the not-for-profit corporation law. It is defined by the IRS, but unfortunately that definition changes from document to document and schedule to schedule. So that's not going to give you the world's best answer to what is control. But I'm going to tell you what I often tell my clients, which is actually what I tell my children in many a situation, is if you have to ask me the question, you probably already know the answer. And in this case, the answer is we better consider whether or not there's some control here and whether it's a related party transaction. So head in the sand ostrich situation here, not going to work for you people. Can't point you to an actual definition of control in the NPCL, but like the Supreme Court has said on more than one occasion, you're going to know it when you see it. So just tuck that one away in the back of your mind. And again, that is why nonprofits have lawyers, because we like to dwell in these issues. All right.
And by the way, Judy, on that note, affiliate, so what we need to remember is that a transaction with an affiliate of the corporation is treated the same way as a transaction with the corporation itself. And again, understanding where this is all coming from, there were instances and a history of affiliates being utilized as an end run to engage in transactions that improperly benefited insiders. And so again, the net was cast broadly to capture affiliates in this related party transaction analysis.
Right. So it gets us to, let's just take a step back for a minute and think about, what about all these definitions and these rules and these requirements? What is the point of all these processes and procedures? And it's actually pretty easy. It's to make sure that the transaction is ultimately in the best interest of the nonprofit. That is your lodestar every day, people. So I'm going to turn it over to David, who's going to dig a little deeper into possible exceptions to the related party transaction requirements. And they're really good and very helpful. And you're going to want to think about employing them. And then we're also going to talk about how to analyze whether something is in the best interest of your nonprofit and how you document that analysis and the document that's going to help you do that, which is, we keep coming back to, the conflict of interest policy. So I'm going to monitor your questions. Let's see if we have one. Oh, these laws relate to New York State. Right. Yeah. So New York State is far more restrictive and more detailed than New Jersey. So if you happen to be with us as a pro bono partnership client from New Jersey, please reach out to my colleagues there. And if you're not, but have a question, email me. My contact information is at the end, and I'm going to connect you to one of my New Jersey nonprofit colleagues at Pro Bono Partnership, and we'll get you some answers around that. But I can assure you that if you jump through all the New York State hoops, you are never going to be not doing what you need to do in any of the other 49 states or territories. And I'm going to hand it over to David now.
Okay, so we're going to dig a little deeper, as the shovel indicates, and we talked a little bit about the definition, which came right from the statute, of what a related party transaction is. And the statute also has a formula for what you have to do if you're going to enter into a related party transaction. And that transaction must be found to be fair and reasonable and in the nonprofit's best interest. So this is process plus substance, and certainly determining that something is fair and reasonable and in the corporation's best interest is substance, but there's also some process here. And so here's a direct quote from the statute. No corporation shall enter into any related party transaction unless the transaction is determined by the board or an authorized committee thereof. I'm going to talk about committees in a little bit, to be fair, reasonable, and in the corporation's best interest at the time of such determination. So that formula, fair, reasonable, in the corporation's best interest, those are essentially magic words. The statute doesn't say that the board has to approve the transaction. That's not enough. Approval isn't enough. You really need to recite the magic words and state the formula that the board has determined that this is fair and reasonable and in the corporation's best interest. And that needs to be in the board resolution, in the minutes that approve the transaction. And if you think about why, so again, the statute is telling you this is not a normal board decision. Here, an insider is getting a benefit from a transaction. And so we want the board not just to approve it, but to shine a spotlight on it and make a determination that in writing that the board finds that this is fair and reasonable and in the corporation's best interest. Another touchstone of what's required is that no related party can participate in deliberations or voting relating to the related party transaction. And I want to just say that sometimes I run into confusion about what that non-participation means. I've had board members suggest to me, well, I can sit there and not say anything, right? That's not participating. And that is not the standard. The standard is that other than answering questions, providing information about the related party transaction and expanding on your disclosure to the extent that the board has questions, you, if you're a related party, cannot be present at all. So silence is not enough. If it's a Zoom meeting, you need to sign off. If it's a board meeting, you need to leave. If it's a phone call, you need to hang up. And that lack of participation and that lack of presence needs to be reflected in the minutes. David answered questions about the transaction. The questions ended. David left the meeting. That's important.
I do want to, I'm sorry, David, but I do want to assure all of my board members out there who are then going to pick up the phone and call one of us in a minute and say, but if the people walk out the door and then we don't have quorum to vote, Judy, good point. Glad you guys all thought of that. And the law actually contemplates that and does note that you are considered present for purposes of the vote for quorum, even though you physically have left the meeting. So please do not let that be the hindrance or the barrier to you actually getting up and leaving. Please, that is not a problem anymore. You might want to take a peek at your bylaws to make sure that they say that, but please remember that that is not going to be an impediment for you. The law really, really wants open and frank discussion. As David said, you got to shine that light. And as collegial as board meetings can be, we know that you may not feel comfortable pointing out a problem with a transaction or a concern, we say concern, if the person's sitting right there. Now, this is not to say that if you have questions about this transaction, you should pepper that person who has the information with those questions, but they're going to get up and leave and you're fine for voting purposes. Oh, and someone had asked a question about conflict of interest policies in Connecticut. You don't have to have one like you have to have it in New York State, but it is across the board a best practice. It is going to enable you to do the kind of analysis you need to do as a board to make sure that you're acting in the best interest of the nonprofit. But Connecticut questioner, feel free to reach out to me. I'm admitted in Connecticut also.
And on that note, just on the Connecticut question, I have a lot of clients that are private foundations, and donate to other nonprofits, to public charities. And that's a question that a public charity would need to answer on its 990, whether it's in New York or not. Do you have a conflict of interest policy? And I can tell you that my private foundation clients, if a potential recipient of a grant says that they don't have a conflict of interest policy, they'll be nixed immediately just based on that answer. So yes, Judy, absolutely, it's a best practice and more. But in New York,
I was gonna say New York State Gateway is going to want to see it too, right?
Right.
All the documentation you load in to get money from New York State, you're going to need that policy. Look, you just really need to have one.
Right. In New York, in New York, there's no way around it. So it's absolutely mandatory and not optional. And so something else that Judy's point about quorum is very important. I'm glad she raised it. And it shows us a couple of things here. When the statute was originally put in place as part of the Nonprofit Revitalization Act in 2014, the quorum provision said that when people left the meeting because of a conflict, they weren't counted for quorum purposes. And the legislature and the Attorney General realized how complicated this statute is and how demanding it is. And they also were open to some of the practical difficulties that nonprofits were having in complying with the statute, and this was one of them. So in 2017, the law was actually amended in a number of ways, and this was one of the ways that it was amended, so that when you leave the meeting, you're still present for quorum purposes. And so that was helpful, as Judy pointed out, but it does open the door to another problem, and it just kind of just highlights for all of us how complicated these provisions are and why you usually need help of your counsel to apply them and implement them. When so if Judy and I are leaving because we've got a conflict or related party transaction, we continue to be counted for quorum purposes, but that means that we also continue to be counted for voting purposes too. So to the extent that there are provisions, and we're going to see one of them in a little bit, that require a majority vote of the directors present, that would include us, even though we're not in the room voting. So it helps in quorum and complicates voting a little bit. It's very important and I understand that that's very technical and complicated, but again, a good reason to reach out to your counsel and make sure that you get the help you need to implement these provisions.
And I do also want to point out, and David's going to get to it with one of my favorite slides in just a moment or two, the law was amended and revised in 2017 because practitioners and boots on the ground people like you said, hey, we get that you want us to be more transparent, and we get that being open and really exploring these transactions is important, but we're also big picture strategic thinkers. And if we have to look at every single related party transaction out there, legislature, governor, we're never going to be able to do our big picture work. So I say that, and David's going to talk through these exceptions in a minute, but I say that so that you know that these rules have such significance and import to the people who run the state and entrust the assets of the public to nonprofits and their boards, that they're willing to go back in and examine and change. But the quid pro quo for that is we've made it easier, but that means you really have to do your job, boards. Like, we are entrusting this to you. We're hearing what we've heard, what you've had to say. We've dug deep and looked to see whether it's still going to protect the public. And this is the bare minimum of what you're going to have to do, and do it well.
So let's talk for a minute about special rules for substantial financial interests. And the first thing I want to mention is that this only applies to charitable nonprofits. We're not going to get too deeply into the distinction between charitable and non-charitable. But this is one provision. There are two types of nonprofits under the not-for-profit corporation law: charitable and non-charitable. The provision we're talking about now regarding substantial financial interest only applies if you're a charitable nonprofit. An example of a non-charitable nonprofit would be a trade association. If there's a substantial financial interest, and by the way, critically, substantial financial interest is in the eye of the beholder. It is not defined. And so that's something to be very careful about. There's no statutory definition, so there's no certainty as to when this is triggered. With respect to a substantial financial interest, there's a requirement that alternative transactions, plural, that means more than one and preferably three, but at least two, consider alternative transactions. So the board, in making its decision to proceed with the transaction, needs to look at alternative transactions. The decision to proceed needs to be approved by not less than a majority of the directors present. That gets to the voting threshold question that we were talking about a moment ago. And the board needs to, or the board committee needs to contemporaneously document the basis for its decision, including consideration of alternative transactions. So let's talk about documenting for a minute. This is a good point to segue into minutes and documentation. So we've got all these hard and fast mandatory requirements that come from the not-for-profit corporation law. We need to be able to have a record of the fact that we complied with them. It's possible to do everything perfectly. And to the extent that it's not documented in your minutes, 2.5 years from now, when somebody raises a question, how do we know that David left the meeting after answering questions? How do we know who voted how? How do we know that alternative transactions were considered and what those were? And so when the statute says that we need to contemporaneously document the basis for our decision, we need to have those alternative transactions attached to the board resolutions and the meeting minutes so that it's clear what the basis for the board's decision was.
Although, David, if I could just shout out for 1 minute, like a little pet peeve of mine, when we say you have to document and document thoroughly, and this applies for minutes across the board, we do not mean give us a transcript. Minutes are not a transcript, nor should they be. They're just the legal record of what transpired. So when you're documenting those alternative transactions, and minutes surrounding these related party transactions are more in depth, you're going to discuss, we considered these 3 alternatives, and it was decided that this transaction was better than alternative 1 because A, B, C, and so on. But we do not need to know that Sally Smith said this, and then Bob Jones said that. We're describing what transpired and what analysis took place. Remember, they're legal documents. We don't want to know every single sentence or every single word that every person uttered. It's going to be important when it's Exhibit A at a deposition. Trust me on this.
So Judy mentioned the exceptions to what a related party transaction is. And again, this came about as a result of the impracticality of some of the original provisions in the law. And these were adjustments made with the support of the Attorney General by the legislature in 2017. And there were 3 exceptions to what constitutes a related party transaction. And the first, and you're going to see a theme here in a minute, the first is it's not a related party transaction if the transaction is de minimis. So what does de minimis mean? It means minimal in some sense. Okay, so how do we know if it's minimal? What's the definition? And here's the theme. This too is not defined. This too is in the eye of the beholder. It's important to be aware that this is not carte blanche, and because there's no statutory certainty as to what the minimus is, it's best to approach this conservatively. And what's the downside if we err on the side of inclusion and saying, well, maybe this isn't de minimis? That means that we need to go through the related party analysis. And if you take a step back and think about what that means that we then have to establish that the transaction is fair and reasonable and in the corporation's best interest because it's a related party transaction. And that's really not a bad thing. So from that perspective, we need to handle that gingerly. De minimis is helpful. A $500 transaction is going to be safely de minimis. But
Maybe.
as we, well, go ahead, Judy.
Well, I was going to say, I'm sorry to interrupt you, David. $500 may be de minimis again for Northwell, but if you're running on a budget of $1,000 or $2,000 a year for some of my really small not-for-profits, like my small community-based, just down in the weeds nonprofits, $500 may be a large, it may not be de minimis anymore. But also, and you may have been getting to this, David, so I apologize if I jumped the gun. You also need to make a decision as to what is de minimis. So it can be a dollar value, it could be a percentage of expenditures, but it has to be consistent. It can't be $500 for this transaction, but $1,500 for this transaction. There's no sort of smushing it around the edges to make it work for you, right? Again, the idea is you got to lift up that rock and look at the transaction. And I tell my clients all the time, at the beginning of the year, they should establish what's de minimis for them. Put it in your minutes, pass a resolution. It cannot be, we change our minds about it every other day.
Good. So the second exception is a transaction isn't a related party transaction if it's not customarily reviewed by the boards of similar organizations in the ordinary course of business, and it's available to others on the same or similar terms. So that's a lot of words there, a lot of prongs to that. I think it's helpful to take a step back and think about the kind of carve out that this was supposed to capture. And I think the thought here was situations like where someone who's involved, an employee of a, let's say a senior staff person or board member of a local utility is on the board of a nonprofit. Well, are we really worried about that transaction being an improper benefit to that board member? And the answer is no, because this is something that's available to everyone, based on the rates that utility charges on the same or similar terms. And this is not the kind of transaction that's reviewed by boards of similar organizations as a matter of course. So that exception is trying to carve out those types of transactions. The third exception comes up actually more often than you'd think. I see this as very relevant with a lot of my clients. A transaction is not a related party transaction if it's a benefit provided to the related party solely as a member of a class of beneficiaries that the corporation intends to benefit as part of the accomplishment of its mission. And the benefit needs to be available to others on the same or similar, and I think terms is hiding, the word terms is hiding behind the aquarium, but trust me, it's there. So let's unpack that because it's complicated too, but in concept, I think it's really straightforward. If my child is attending a nonprofit camp, the tuition that camp charges is, if I'm on the board of the camp, is a related party transaction. It's a financial transaction between me and the camp. And so here, of course, that tuition is that benefit, the price of tuition is available to others on the same or similar terms. And the beneficiary of the camp is my child, and the camp intends to benefit children as a part of the accomplishment of its mission. So that really shouldn't be, and it is not as a result of this carve out, a related party transaction. This comes up also very often in the context of non-charitable nonprofits. So as you might imagine, trade associations, I mentioned before as a prime example of a non-charitable nonprofit, this comes up in terms of the fees between trade associations and the trade association members. Similarly, that's a benefit available to others, and it's basically the accomplishment of the organization's mission. So it's carved out. It is not a related party transaction, and we don't need to worry about it. Okay, so some things to keep in mind, and critical to the conflict of interest and related party regimen in the statute is who does this all apply to? And that early slide, directors, officers, key persons, again, a very complicated definition, but then relatives of any of them or entities that any of those persons or relatives have a certain level of interest in. That is a very broad net, and that's something to always keep in mind. And you use my example of the domestic partner of my great grandchild as a cautionary signpost to remember that this is a very wide net, and it's very important to always keep in mind who does this apply to. And remember, we're talking about transactions not just with the corporation, but also with affiliates of the corporation. Is money the only thing that matters? It's not. Certainly appearances matter, time and circumstances matter. Sometimes there are safety issues involved with a proposed related party transaction. I have a client that works in countries in the developing world, and sometimes in environments where their staff faces a significant amount of personal danger. And so having accommodations and housing for staff in a very safe environment is critically important. What happens when those accommodations are being offered by a board member, a local board member, that and then what you've got is a related party transaction, but you've got a very pressing need to enter into that related party transaction. And this is a very important tension that I see come up in lots of organizations. And what I find, sometimes a client tells me, look, we really need to go forward with this. We need to do it quickly. There are very compelling reasons. And I ask them to sort of slow down only a little and take a step back, because what I've found in virtually every instance is that notwithstanding the fact that the statutory requirements are detailed and complicated, they're very manageable. And so even in my circumstance where there was a compelling safety reason to move forward, it was pretty easy to put together alternative transactions and to demonstrate the advantage of the safe environment being proposed by the transaction with the board member. And so that's really important to keep in mind, that when we create that record and we create the paper trail for having complied with the statute and having done what's fair and reasonable in the best interest of the corporation, that that is something that is actually fairly straightforward to do. We just need to have the discipline to stop and do it before we proceed with the transaction.
Right. And David, I would be remiss if I didn't point out we only had 5 minutes, and I want to make sure you cover conflicts of interest policies.
Wow, time's flying when we're having fun. Sorry about that. I apologize. I didn't realize we were that well in. So conflict of interest, I'm going to skip to that, and I'll start talking a little bit faster. I apologize. So the statute in section 715A has a provision that really lays out what needs to be in your conflict of interest policy. And as you might expect, key is the related party transaction provision, which is in section 715 of the statute. But then this section of the statute, 715A, opens the door to non-financial conflicts, because it mandates that the board adopt and oversee the implementation of and compliance with a conflict of interest policy applicable to directors and officers and key persons, to ensure that the directors, officers, and key persons act in the corporation's best interest and comply with applicable legal requirements. And we highlighted ensuring that those directors, officers, and key persons act in the corporation's best interest, because that's incredibly broad, and in fact is broader than merely a financial transaction, and it opens the door to the kinds of non-financial conflicts. And I'll give you a classic example of that. If I'm on the board of a nonprofit, and my wife is on the board of the local library, and the nonprofit that I serve on has rents the library for a function, that's a conflict of interest, because if I'm thinking about my wife, I may want to go forward with that transaction, but I need to look at it from the perspective of the nonprofit whose board I serve on. Yet there's no financial interest. If we go forward with that, my wife nor I, neither of us is getting any financial benefit. So transactions like that are non-financial conflicts, and what Judy referred to as soft conflicts of interest. And that's something that you may want to have as a section of your conflict of interest policy, so that your organization has a way to deal with those to ensure that the corporation's best interest is kept in the forefront.
2 minutes, and I want to make sure people know what to do if they didn't ratify, David.
Okay, good.
If they screwed up.
Good. And okay, so if you screwed up, we're going to, and by the way, there's some slides in here on annual disclosure. Remember something about annual disclosure before we get to ratification, is that the statute requires annual disclosure under the conflict of interest policy, but also requires disclosure prior to initial election to the board, number one, and number two, when any conflict occurs. So I can make a conflict of interest disclosure today, and in 6 weeks, I can have a conflict of interest, and that doesn't wait a year. That requires an immediate disclosure. So getting to potential for ratification, this applies. This is on slide 38, and it's a provision that was also added in the 2017 amendments. It applies only with respect to a potential claim by the Attorney General, if you screwed up and you didn't follow all of these procedures and required steps, if prior to the Attorney General coming and knocking on your door, sending you a letter, in good faith, you ratify the transaction based on the fact that you have made a finding that it was fair and reasonable in the corporation's best interest at the time it was originally approved. So basically, you're going back and doing what you should have done in the first place. If there's a substantial financial interest, you need to have considered alternatives. You need to document the basis of your ratification, and critically, you also need to document the nature of the violation, and that you've put in place procedures to ensure future compliance. And if you do all of that before the Attorney General comes calling, you will have retroactively complied, and the statute allows you to do that. So I apologize, but it's 1 o'clock. Sorry that we didn't get through everything. As Judy mentioned, we've got some very helpful forms that were distributed as part of the materials that will provide you with a checklist on how to organize and manage some of these activities. If I had to end with a couple of really salient points, one is what Judy said earlier, that the statute is certainly not a prohibition against conflicts of interest and related party transactions, but it's a roadmap for how to enter into them, A, in compliance with the law, and B, in a way that's in the best interest of the organization. And as you can see, this stuff is really complicated, so don't hesitate. And in fact, you really have to reach out to counsel for help in getting through this and in documenting it properly. And on that note, we thank everyone for attending. We encourage you, if you're not a nonprofit partner of the Nonprofit Resource Hub, please go on our website and look at some of the resources we provide. Becoming a nonprofit partner is free of charge, so we certainly encourage you to do that and look at some of the benefits that entitles you to on our website. And we want to thank nonprofit Westchester for sponsoring and promoting today's webinar. And we thank you all for being here. And thank you, Judy,
My
for doing such a
pleasure.
wonderful job.
My pleasure. Thanks, everybody. Hope to hear from you soon. Don't be a stranger. Bye-bye.